Please, Your Lordship.
Yes.
I'd like to mention item number 5, Your Lordship.
Five.
Lordship may kindly take it up on Monday, Lordship.
On?
Consent from the other side, Lordship.
You are?
And for the petitioner, Lordship.
So why do you want adjournment?
Lordship, we are being led by Dr. Saraf in this case.
Mhm.
Due to some personal urgency, Lordship, he could not appear today, Lordship.
Okay. A request is made to adjourn the matter. On behalf of the petitioners. The other side has no objection. List after 2 weeks.
Lordship, Monday, Lordship.
Monday would not be possible, sir. You can either have it today or it goes after 14th. You can take any date after 14th, whatever is suitable to you.
Highly obliged.
Or you may, maybe you can have it on 10th April if you want.
10th.
Yeah, that's a Monday.
Monday.
Yes.
10th April. All right.
Highly
Deeply
obliged.
obliged.
Yes.
May I please, Lordship? With the
Yes.
consent of other side, I'd like to mention item number 14.
14. Yes.
I'm appearing for a petitioner.
Hmm. And counsel for the appellant has circulated an adjournment slip. The other side has no objection. List after 2 weeks, 4 weeks rather. Yes.
Item number 1 of daily list for motion.
May I please, Your Lordship?
Lordship, Mr. Deenath is appearing on behalf of the state Lordship. He is on his way, Lord.
We'll issue notice and call them to file an affidavit.
All right, well.
Issue notice to the respondents. Mr. Deenath, when government counsel appears for all the respondents.
For
Thus,
respondent numbers 1, 2, 3, and 4, Lordship.
1, 2, 3, and 4.
Lordship.
Thus, requisites be filed for effecting service upon the response numbers 5 and 6, 5, 6, and 7 within 3 days.
Very notice issue.
Mr. Nath shall file affidavit of factual report on behalf of the response numbers 1 to 4 by the next date of hearing. List on rule is made returnable on 25th April. List on 25th.
But in the meantime, my lord, there is a small mistake, my lord, typical mistake in page 13, my lord.
Yes.
The second para, my lord, actually, this is a para of another FIR that was invented.
Counsel for the petitioner is permitted to
I may be,
rectify the
my lord,
typographical error in the memo of petition.
my lord, place the new page, my lord, here. Highly obliged, my lord.
Item number 2.
Well, before I start, I must offer my apology, Madam. In the second copy, my Lord Justice Takori, page number 6 has been repeated twice. My error.
Don't bother,
apologize.
don't bother.
It's a contempt application, Madam.
Yes.
Uh,
What is the order under contempt?
17th of May 22. That's
Yes,
at page 20 onwards, the operative part at page 23.
yes.
In fact, it's a continuation of the order passed by the Honorable Single Judge.
Mhm.
The directive that 4 writ petitioners therein should be accommodated in any vacancy, and the government also considered to that effect. So in the
Okay.
writ appeal,
Have you filed any representation after this order?
absolutely, page 24, that's 23rd of November 22.
Have you filed any representation?
Yes, page 24.
24. Okay. Heard issue notice to the response numbers.
2 respondents,
Both
both
are responsible
Both.
for compliance.
Lordship.
Issue notice to response numbers 2 and 1 and 2. Steps for service be taken within 3 days. Rule is made returnable in 4 weeks.
Obliged. Grateful.
Item number 3.
May I please, Your Lordship.
Yes.
Lordship, we have filed our written argument
Okay.
on behalf of the petition.
So you want to close the things on written arguments?
Written argument, my lord, we'll conclude on written argument, but we would like to conclude on the written argument part.
Yes,
But in respect of the contentions, if they raise, we must we must be allowed to avail an opportunity to give them a reply.
they don't need to give a reply. Why you presume that they want to give a reply? They will argue orally. We'll hear their oral arguments. This Nair is here. So you have concluded by the written arguments. Okay, very well. And what is the page number?
Page number, my lord, we have filed it today. Today itself, we have filed and we
Get
have
the written
served the
arguments.
copy.
Yes. So 13-4 matter. There's a. Yes, Mr. Nair, you can argue.
My lord,
You please give the brief outline because
lordship.
the earlier bench which heard,
My lord,
Saikia was there.
My
Now
lord,
my sister is.
before I take my lord to the dates, one
Yes.
factor I'd like to bring before my lord. There are
Yes.
two petitioners before my lord.
Yes,
These two are different companies. The directors may be the same.
okay,
Now, petition number 1 and petition number 2 both had avail loans from us.
right.
Petition number 1, my lord, there is no area now. It's already a closed account. The dues have been cleared.
Dues have been cleared.
But
So,
still they have come up as a petitioner before my lord. I don't know why.
so would you be dropping the proceedings?
Against one already dropped, my lord.
Already dropped.
It's only against this petition number 2 that, my lord, the whole issue is there.
Okay. Can we find it from your reply,
Yes, your lordship.
from your affidavit?
Yes, your lordship. My lord would have. My lord, page 111, para 7, my lord.
111.
111. Oh,
Whereas 7.
7, my lord.
Yes,
That it is further stated that the petition number 1 has no locus to file the instant writ petition as a said petition number 1 company. Neither has any grievance against the respondent number 1, 2, and 3, nor is now connected with any securities of the petition number 2 company. And most importantly, the loan accounts of the petition number 1 company had been since liquidated in full under one-time settlement.
yes,
Now, my lord, it starts with my lord, on 23/9/2011. It's only petition number 2 now, my lord. 23/9/2011,
2011.
11, my lord. A term loan of rupees
Yes.
7 crores was sanctioned,
Okay. So, right.
lordship. Then, my lord,
No,
They
we were asking you the date of settling the loan account of petitioner number 1.
my lord, that date was not given, but before, my lord, coming to this court, they had settled it, my lord.
Okay, very well. All right.
Then, my lord, with regard to petition number 2,
Yes,
the loan was sanctioned on page 46, my lord. The loan was sanctioned on 23/9/2011. 7 crores.
yes,
And, my lord, this was secured by the personal mortgage made of personal property of the directors, 2 directors.
yes,
Then, my lord, they failed to liquidate the loan. Accordingly, my lord, we issued a possession notice on 19/5/2017,
yes,
and the due was 5.23 crores. My lord. Then, my lord, they come up for a
Yes.
compromise settlement. We on 37/2019, my lord, we compromise one-time settlement. The amount fixed was, my lord, I'm just giving a approximate amount only, my lord, 4.57 crores.
2019 date.
Date, my lord, 37/2019, page 67, my lord. Now, my lord, this,
Yes,
my lord, we had accrued some interest which was there, around 2 crores we had left out. And the amount was to be paid from the period 1/8/2019 to 1/7/2020. My lord, they failed.
yeah,
And accordingly, my lord, we started with the proceedings again.
yes,
And, my lord, the possession notice again was issued and we had taken over the possession of the property.
yes.
Now they again come up before us for extension of the
Mhm.
period.
Right,
My lord, accordingly, on 31/3/2021, the one-time settlement made
Hmm.
was extended till 31/3/2021, extended till 31/12/2021. This is at page 77, my lord.
Yes,
And the amount is, my lord, 2.71 crores. Approximately.
yes,
But my lord, in spite of two extensions, they failed to, my lord,
Mhm.
pay the money. Accordingly, on 27/5/2022,
Yes.
page 88, we revoked that.
27,
Eight.
5,
27/5/2022, my lord.
yes. OTS
will-
revoked.
The OTS revoked, my lord. And a demand, my lord, as on 1/6/2022 of
Yes.
5.22 crores were made. Approximately.
Okay,
Then, my lord, we proceeded for auction sale. In the first round of auction sale, my lord, we could not get any buyer. Thereafter, we reduced the price by 15% and then we put it to auction sale. That auction sale notice was of, my lord, December 2022. December 2022, my lord.
yes,
16/12/2022, my lord. 16/12.
yes,
And accordingly, my lord, the matter was auctioned. The property was auctioned. And an auction buyer, my lord, the highest bidder, he gave a value and he has deposited 25% of the
Mhm.
amount.
Okay,
But my lord, because of the pendency of this proceeding and status quo, we have been extending the time for deposit of the balance amount. And that is pending as such, my lord.
right,
Now, my lord, the basic query, the basic grievance raised by the petitioners
yes,
is, my lord, that there is a NCLT proceeding under the IBC Act pending. And as such, there is a monitoring. In not so many words, but that's a projection made. So in that view of the matter, the corporate debtor's property cannot be, my lord, looked into. But we have not gone against the corporate debtor, my lord. We have gone against the personal mortgage.
personal mortgage.
Personal mortgage property, and there is no bar under that. Second, my lord, they say that, my lord,
Yes,
there is a bar under 31J of the Securitization Act.
yes,
If the due amount is less than 20% of the, my lord, if they have paid more than, my lord, 80% of the
80%.
amount, then, my lord, a proceeding before the surface court would not lie, my lord, before the DRT.
yes,
My lord, herein, I would like to draw my lord's attention to paragraph 14 of my written statement. My lord, their calculation is on the OTS amount.
naturally, that
We
would be, there may be so many considerations in OTS.
OTS, my lord. So,
Yes.
but we have said once that has failed, my lord, we'll have page 115, my lord.
Yes. That we noted.
That so far as the
because-
contention of the para 14 last, my lord.
Yes,
That so far as the contention of the petitioners that the Honorable DRT has no jurisdiction to entertain an application under so and so Surface Act is wholly misconceived and false, as because the petitioner has willfully misrepresented the facts. The petition number 2, company claimed to have paid for 4 crores 30 lakhs out of the total OTS of so and so, and the percentage of payment comes to 74.39. But the
where are
petition,
we reading, Mr.
my
Nair?
lord, I'm reading at page 115, my lord. Para
15, all right, yes,
Sorry, my lord. Para 14, my lord.
para 14, yes,
That so far as the contention of the petitioners that the Honorable DRT has no jurisdiction to entertain an application under section 17
Hmm.
of the Surface Act 2002 is wholly misconceived and false, as because the petitioners had willfully misrepresented the facts. The petition number 2, company claimed to have paid rupees 4 crore 30 lakhs out of the total OTS of 5.77, and the percentage of payment comes to 74.39. But the petition number 2, company had calculated the percentage payment of percentage as 81%, which is wholly incorrect. This is one, my lord. Now, my lord, 2.
now this calculation,
Lordship,
15 crores, that amount of 5 crores has blown up to 15 crores.
15 crores.
Total
they have-
outstanding,
they
but
have paid-
you are
they-
doing it, clubbing the two amounts together. Mr. Nair, there seems to be some mistake,
No, my lord. This 15 crores
Is
is for
club-
petition number 1 and petition number 2.
both.
Both together,
Yes.
not one, my lord.
So, but then regarding two,
Two.
regarding one, you say that the loan account is already closed.
Clear, that's included in that 10 crores, my lord.
Okay,
I'll just read that paragraph.
yes,
In absence of OTS, which no longer survives, the total outstanding in the account comes to rupees so and so. And out of the said account, only an amount of so and so has been received from the so and so by the corporation during currency of the loan.
now this,
So and so.
Mr. Nair,
Lord,
out of the said amount, only an amount of rupees 10 crores
Crores.
odd
Odd.
had been received from the petitioner number 2 company.
by
So how
the-
do you close the account of the petitioner number 1?
My lord, there is a drafting error here, my lord.
Yes.
It's actually both, but my lord, they
How
have
can we
taken-
read that?
but they have taken that both together. It will not of one, no?
This
One and
is-
two, one and two, my lord. It's 1 and 2, my lord, together. Because my lord, in the OTS thing, they had made it together. Maybe it's an error, my lord. It's an-
Can you support this submission by
Yes, your
document?
lordship. I can
Yes.
support that straight away.
Please,
My lord would come to
because even when you calculate the percentage,
lordship,
you are doing it for the entire amount.
lordship. My lord would come to the rejection, my lord. If your lordship can come to page 88 of the writ petition, my lord.
Yes. That is revocation of OTS.
Lordship.
Yes.
I'll not trouble my lord with the facts. My lord may come to page 89.
Yes.
As per the compromise settlement, my lord has got it. As per the compromise settlement, an amount of rupees 2,71,61,830 was to be paid in 10 monthly installments starting from so and so and ending with so and so. However, you have failed to adhere to the terms and condition of the compromise settlement extension, and as on 35/2020.
Mr. Nair, this letter is written to whom?
This letter is written to my lord Sri Prakash Alloy.
Petition number 2.
Petition number 2, my lord.
Okay.
And the dues, my lord, would get it from there, my lord.
Mhm.
However, as per the compromise settlement, an amount of rupees 271 crores was to be paid in 10 monthly installments, starting from 31/3/21 and ending at 31/12/21. However, you have failed to adhere to the terms and conditions of the compromise settlement, and as on 35/22, the balance amount to be paid was 1,64,36,74.
Mm.
In this regard, several reminders were issued to you and follow-up action were carried out, but you failed to complete.
Right.
As you have failed to comply with the terms and conditions of the compromise settlement, offer letter, as well as the extension of net fee, hereby revoke and the compromise settlement of the above referred loan account. As per the terms and conditions, net fee reserves the right to recover the entire dues along with the documented interest rate and other costs, and also reserves the right to take necessary legal recourse for recovery of the entire loan.
So meaning
outstanding
thereby, Mr. Nair,
in this regard.
so far as this government made in reply, that is inconsistent with this document.
It's my lord. I'm sorry for that, my lord. In this regard, as on so and so, you are requested to pay the balance amount, principal 119.72 lakhs plus interest of 40.67. My lord, because we have not taken the rebate given in the OTSs, my lord.
Naturally.
So it goes back to 522, and I can, my lord, even show that 522, how we have come to that.
Mm.
That is the rate, my lord, at page 73, when we issued the surfacing notice.
Surface notice.
That's the amount, my lord. 522.27, it has gone up to 39.
Right.
My lord would have page 73,
Yes.
the first paragraph, 1, 2, 3, 4,
Yes.
5, 6 lines on bottom, my lord.
Yes. 5 crores, 23 lakhs.
Lakhs 27,643. Now it has gone up to 522.39, my lord. Because this was in, my lord, 25/2/2021, and the letter is of 27/5/2022.
Yes.
So, my lord, in that view of the matter,
Mm.
the amount that has been paid remains so much. My lord, that 20% calculation will not come here, my lord. In that view of the matter, now my lord is with the affidavit. My lord may only come to no, my lord, with in the writ petition. My lord, page 190. They had approached this honorable court earlier,
Earlier, yes.
and there is a specific direction.
191.
It starts at 191, my lord.
yes.
91, my lord. 191.
Yes.
So and so also, the petitioner has approached this court against the vacation notice which has been passed by the secured creditor of the respondent bank under the provision of so and so. The admitted position is that the petitioner had taken a loan from the respondent bank, which he subsequently could not repay in time, and therefore the amount has been declared as MND. Proceeding has been initiated so and so under the proportion, and this concurrence the petition has been filed, challenging the order passed by the secured creditor of the respondent bank under the act. All the same, the petitioner has a statutory remedy to file an appeal before the recovery tribunal under
DRT.
section 70.
Yes.
Then, my lord, there was a delay,
Mm.
and
The
page
delay was
193 last, it said you could favorably consider. They did not exercise that time, and they are before your lordship with this plea, my lord. So in that view of the matter, my lord, this writ petition itself is not maintainable, my lord. I would pray, my lord, the writ petition my lord, is required to be dismissed, and my lord, the interim order operating is to be made so that we can recover the dues. Madam. And 25% have been deposited, 25%.
Yes.
This is my humble submission.
Yes.
My lord, so
You
far-
already conveyed that you will be concluding your arguments through the written submissions.
Yes, my lord.
You want to say something orally also,
Yes, my lord.
please?
I have, I would like to raise a contention, my lord.
Yes.
far-
What do you say about this order at page 192? Whether you have disclosed this fact in your writ petition?
It's in the writ petition.
It's in the,
It's
well, how do you explain this?
they have explained.
Not following this direction?
My lord, so far as the order
Yes.
directing us to approach before the depths, before the DRT. My lord, at that particular time, my lord, due to some inconvenience being occurred on the part of the petitioners, my lord, we were unable to approach.
So, was it discretion left after this order, sir? But you could not approach the DRT and then again file a writ petition?
No, no, so far as this writ petition is concerned, my lord.
Yes, please.
Our basic issue pertaining to the writ petition is that, my lord. So far, my lord, the payment of the loan amount is concerned, my lord. Two petitioner companies are standing before your lordship.
One petitioner company,
They, or one.
if loan is,
company-
account is closed.
Yes,
Settle,
settled, my lord.
yes.
But my lord, so far as the term loan is considered, so far as the term loan is considered, in total, my lord, there was 12 crores of term loan. But out of that, my lord, we have already paid 17 crores, and in respect of that, my lord, in our affidavit, in our rejoinder affidavit, my lord, we have filed the certificates. It has been issued by the chartered accountant.
Mr.
Very-
Nair,
Manoj, I'm
we have-
sorry. One mistake, Manoj. I'm sorry. This is in the affidavit that have been filed. They have not disclosed that in the writ petition.
that is what,
Well,
because
sorry,
this is
sir.
coming at the end.
I was on a different,
This was coming at the end.
at the end.
Yes. This is an affidavit filed by you.
Yes, Manoj.
What do you say to this, sir? Non-disclosure of this fact. Come to that now first. Non-disclosure of this writ petition. What have you to say about that? Before you entertain any of your arguments or merits, what do you have to say about this?
My lord.
Why shouldn't we penalize the petitioner with exemplary cost for this?
My lord, during the relevant times, my lord, inconvenience was there. For that reasons only, my lord, we could not approach before the concerned DRT.
That's all what you have to say?
Yes, my lord, I also the
What do you say first to this? We don't proceed an inch beyond this.
Right.
Non-disclosure of a matter filed in this court in relation to the very same controversy. How can a litigant dare do that? We will not allow any of your arguments on merits. No question. And we'll mention it that we are not entertaining any of your arguments on merits. Do you dispute that you have not disclosed this? Read your pleadings first. Let us be sure about it.
petition of petition of civil being
Yes. Is there supposed to be a footnote below the writ petition? Because Mr. Nair,
Lordship,
we have to change that. In Rajasthan, there is a system of a footnote at the end of the petition, wherein there is a declaration that no such petition has been filed either in the High Court or in the Supreme Court.
I think we
That ought to be there. Yes,
have a paragraph here.
let us see.
No.
We'll incorporate this in the rules
Lordship, Lordship,
immediately.
Lordship.
Yes, Mr. Council. Do you have to say anything about that?
It should some time, my lord. to get-
Absolutely no, sir, not even a minute. Dismiss for non-disclosure of metal fact with exemplary cost of 5 lakhs. The parties have to understand, they can't take the court for a ride. We'll dictate the order. And Mr. Rupam, get the earlier writ petition from the records.
But one fact I like in the reply to my paragraph 17, they say that that writ petition was on a different footing altogether.
Yes, yes.
That much only.
They did not
They did
disclose
not-
it
no, no,
in
the
their
writ petition is not.
writ petition. That is what the first and foremost thing is. Yes. Okay,
Much.
you may carry it further, no issues.
Item number 4,
Yes,
Ah, good.
and get the rules. Ask them to immediately start working on that. In every petition, either it is a bail application or a writ petition, there is a footnote. Get a copy from there. Up to my private secretary, he will get you the copy. Even in the rules, there is provision. There has to be declaration that no such petition has been previously filed, either in this court or in the Supreme Court. Yes.
Lordship, I think, while filing Lordship, that kind of a notice, please Lordship, by the advocate's plan.
There should be.
In
That is there.
petitions, my lord, we file, normally, we write a paragraph.
Because in this petition, we don't find.
Not there. my lord.
Yes,
Normally.
that is probably consciously done
Maybe,
because they
my
might be
lord,
aware of it.
The last 3 paragraphs normally are, my lord, copy pasted, so sometime, my lord, it goes away.
But
Not because-
there in Astana, the petition would not be accepted
if
if
that-
the footnote is not there. It's in the form of a footnote,
It's better. my lord.
mandatory.
It's better.
Yes, we'll incorporate.
Lordship.
Yes,
Lordship, in this particular matter, Lordship, we are challenging the process in which Lordship, grade 4 and lower category of course, Lordship in NRL, Lordship, Nimoligo refinery.
this is challenge to the rules,
We challenge to the rules, Lordship. And
whether they are
the-
statutory rules.
They are not statutory, but it's a government company, it's our recruitment rules, my lord, from 1997. Lordship.
You don't even have any consideration for reservation.
We have, my lord. The reservation
No.
is there. Yes, your lordship.
Where- In
My
what
lord, my
manner?
lord would have it.
What manner?
Because the reservation, my lord, would be,
In what manner, sir?
my lord, it's said,
Read, please.
my lord would come to,
These rules, you stand on this side and tell us, can these rules stand to scrutiny? They are height of arbitrariness.
my lord, there is, my lord.
Yes,
When the matter, the similar matter was before the honorable single judge.
yes.
The similar questions were put to me as to how this was. But that time I could not answer, my lord, because I was not prepared.
Rule 18.1.
18 point. Candidates belonging
Where
to
is-
so-and-so?
Where is that breakup of reservation?
My lord, that breakup we will have, my lord. It's not that we don't have it. We'll have that because the company, my lord, has been recruiting and my lord, we have been recruiting persons with a reservation also. My lord would come to page 36, my lord.
Where is the women quota?
We have a special act here, my lord. 30%. My lord, it comes to page-
Reservation,
my lord,
reservation,
that I can satisfy your lordship. My lord,
Yes.
page 36, my lord.
yes. My sister has a serious objection to your rules.
But in Assam, we have a separate rule for that, my lord. Act for that.
Yes, has to be. Yes,
My lord, page 36,
yes,
my lord, this is the notification made.
yes.
My lord would see here, it's made category wise, my lord, reserve category wise, plus unreserved, my lord.
So how many are the posts?
My lord, it varies from cadre to cadre, my lord.
Okay.
It varies from cadre. My lord,
So how many vacancies have been advertised in this one?
here, my lord, it would be in one cadre, my lord, engineering station operation, the graduate trainee, grade 5. It's my lord,
Mr.
9,
Nair.
10, 14,
Out 9
16.
unreserved and
5, 6, 7, my lord. It's,
2 only for SCST.
no, my lord,
Article
OBC
16.
is there.
OBC is not 16.
My lord, I'll have to, my lord, for that, then my lord I'll have to get the total cadre strength for that.
Yes.
If there is any error in this, my lord, this can be rectified. There is no problem on that.
And then this local reservation,
My lord, that's what,
Big.
that's my lord. subject
can
to-
can it be a blanket?
My lord,
See, you examine the acts of the national law universities.
lordship,
There is local reservation, but to a certain percentage.
percentage.
Can't be a blanket reservation.
My lord, what we have done here, my lord, in the recruitment rules, we have said we will notify it to the local exchange for the grade 4 and 5 posts.
Yes.
Now, local exchange, my lord, there are two, there is an act, my lord, called the Employment Exchanges Compulsory
That is there.
Notification of Vacancy Act.
Yes,
My lord, page 53.
yes.
If my lord can come to, this is what my lord, what I found that the notification is not wrong, subject to what my lord would finally say.
Right.
2F, my lord, page 54,
54.
lordship.
Yes.
My lord, 2F says establishment in public sector means be covered by 2, my lord, a government company defined in so and so. Then, my lord, 4.1, page 55.
Yes.
After the commencement of this act,
Yes.
in any state or area thereof, the employer in every establishment in the public sector in that state or area shall, before filling up of any vacancy in any employment in that establishment, notify that vacancy to such employment exchanges as may be prescribed. We have prescribed it as, my lord, local exchange. Now, in the rules, my lord,
Yes. As may be prescribed.
as may be
Prescribed where?
where, my lord, that it's not there. But my lord sees 4.2.
Prescription can't be at your whims.
My lord, I'll come to that.
Yes.
4.2, my lord says, 4.2.
4.2. Yes.
When there is, it's a private concern, the appropriate government may, by notification in the official gazette, require that from such date as may be specified in the notification, the employer in every establishment in private sector, or every establishment pertaining to any class or category of establishment private shall, before filling up of any vacancy in employment in that establishment, notify that vacancy to such employment exchanges as
So
may be
this,
prescribed.
this
Here the government has
task
to give.
of notifying which exchanges you will approach, that is left to the government.
No, my lord, in 2, it's left to the government.
Yes.
But in 1, my lord, it's silent. So, my
Yes.
lord, I refer to the rules, my lord. Rule 2, this one? Rule 2.
Private sector, yes.
It's 2 is with regard to private sector, my lord. 1 is for, now, my lord takes up the rules.
Yes.
Here, my lord would find rule 2.5, my lord. First page, rule 2.5. Just there is a word.
Just one. Yes, rule.
Rule, my lord, 2.5, my lord. There's a bracketed box 2 written before that.
Yes, yes.
Local employment exchange. This is the word we use. Means in the whole of India, except the Union Territory of Chandigarh, that employment exchange, other than the central employment exchange, notified in the official gazette by the state government or administration of the Union Territory, as having jurisdiction over the area in which the establishment concerned are situated, or over specified classes or categories of establishment.
So you
concerned
mean to
with
say that local employment exchange
lordship.
comes through these rules,
These rules,
which
my
are
lord,
not under challenge?
which are not under challenge. And even the, my lord, the earlier rules are not under challenge. And
Lordship, these are not a private company, Lordship.
So no, this is for the public sector
public
undertaking.
sector under
These rules,
these rules.
read the rules. This designation, local public, this
Local exchange.
exchange comes through power conferred by this rule 5.
And now my lord leads section 1 in light of this clarification.
Yes.
It will be, my lord, the local exchange. It may be wrong, my lord. But my lord,
Yes, but
we
for
have a
that,
justification for that.
for that, you have
We
to
have a
challenge
just-
these rules.
Lordship, I have not gone through, Lordship. For the time being, Lordship,
You'll have to challenge these
I will
rules.
have to go through it. Lordship.
Yes,
For the DD.
Mr. You can, senior counsel, representing the respondents, has drawn the court's attention to so and so rules 1960 and urges that the action of the respondent undertaking in
Notifying.
notifying the vacancies to the local employment exchange is being taken by virtue of powers conferred by rule 2 sub-rule 5 of the above rules. He submits that rules of 1960 not having been challenged, there is no merit in this writ petition. Mr. Bhagwati prays for time to complete his instructions.
Lordship,
List after 6 weeks.
Lordship.
Yes.
At the first glance, my lord, I was also the first time under that view, but then I got this much.
I will
Much
go
obliged.
for it, Lordship. I will please your Lordship.
6.
Much obliged.
Item number 6.
My lord, this petition has been preferred by the Union of India Postal Department, my lord. Against my lord, the order, my lord, dated of the CAT,
Gentlemen,
my lord.
transfer order was passed in 2020.
My lord, yes. Subsequently, my lord, we have filed.
Now,
my lord-
what, why don't you do this? You withdraw that order, pass a fresh one. That order was interfered only on the ground that it was in mid-session.
Subsequently, that is over, my lord. But thing is that, my lord, there is a liberty in the interim order, my lord. We may file MA, miscellaneous application. We have filed that MA in 22nd of February 21. But subsequently, they have filed the my lord, contempt case, my lord. But without adjudicating the MA, my lord. Order passing.
All right, then let notice be issued to the respondent. Issue notice,
My lord.
heard, issue notice to the respondents. Steps for service be taken in 3 days. You want dusty service?
My lord, my lord.
Dusty service is permitted, rule is made returnable in 3 weeks.
Till then, my lord, if
Where is the prayer for interim relief?
my lord, interim prayer is there, my lord. This 18, my lord.
What stay do you want?
My lord, yes, that main order, my lord, 16, 10, my lord, 22, my lord.
Thereby your transfer order has been interfered.
My lord.
Why should we stay that order? The employee is working there.
No, my lord.
Then-
My lord,
He joined the transport post.
my lord, actually, he has not joined also, my lord. For 3 months, we give him salary, but subsequently in the new earlier post, my lord, and another person was already
You
recruited.
get him served. We'll consider everything after that.
My lord. I'm obliged, my lord.
Item number 7 for admission.
My lord, before I take my lord to the merit of the matter,
Yes.
my lord, there was an IA file because respondent number 5 in the meantime, my lord, had expired. And he
Yes.
had brought his hairs on record.
Mhm.
Notices were issued, my lord. But my lord, there is no order, my lord, impleading them as, my lord, respond number 5, 1 and 2, my lord.
You moved the application.
I have moved the application, notices were sent to the highest, the copies were served, but my lord, they have.
Notice has been served on
Served,
the
my lord.
units.
That's my instruction.
All right.
Served, my lord.
Is there a report?
There is a report, my lord. I'll just place that.
Hmm?
My lord would have
No, this is the
22-22, my lord. Order dated 22-22, my lord. The order, my lord, order of this. report, my lord.
22 to
22-2, office note dated 14-23 indicates service is complete, my lord.
this is in the IA or the writ petition?
My lord, it should be. My lord, it should be in the INE.
Yes.
Writ
yes.
petition, my lord, sorry.
Writ petition. The
Office note
service,
dated 14
office note is
14
all
to
right.
23, my lord.
application for impleadment, number so and so. Notice has been served on the LR of LRs of the respondent number
5.
5 within bracket since deceased. Notice of the application. No one has appeared on behalf of such LRs. Thus the impleadment application is allowed. You will file amended cost title or you will do it by hand.
I'll do it by hand, my lord.
Normally in there we don't allow because that makes it very difficult
My lord,
to
we'll,
upload the
my lord,
amended cost
we'll
title.
file an
The
application.
amended cost title be furnished within
We'll do
7
that.
days.
We'll do that.
Within 7 days.
7 days, we'll do that.
List for admission thereafter.
Lordship, we'll do that. my lord. Much obliged.
Because
It's, I got it.
if you see the Rajasthan High Court website,
Hmm.
every component of the file is online.
Okay, my lord.
Everything except for pleadings as so far.
Lordship, other
So
names.
everything, names, steps taken, defects.
Oh.
We are trying to incorporate that.
Hmm.
Maybe you'll find the change in 7 days.
7 days. Lordship, that will be helpful. my
So
lord.
these These handwritten things,
Will not.
They are
do it.
thing of
I
past.
understood by laws.
yes.
Much obliged.
Item number 8,
Yes.
Lordships, unfortunately, after signing the report before the mediator, the respondent is not complying with any of the terms, Your Lordships. I do not know what to address Your Lordships on. Having wasted 8 months of the mediator's time as well. Now he has refused to comply with any of the conditions which he has himself signed just a month back, Your Lordships.
What are the
I-
conditions? Can we know?
Lordships. The settlement was, the habeas corpus petition was filed, Lordships, for the seeking.
Seeking custody of the
child.
Yes.
As per an interim agreement, he had agreed to hand over the child to me. The child is right now in my custody.
Child is with you.
Yes, Your Lordships. Interim, as per the interim settlement. Thereafter, he himself made a statement that his parents were extremely unwell, and so he could not take the child back at that relevant point of time. As such, the honorable mediator continued with that interim settlement. Thereafter, they both decided to settle all their disputes because there were several litigations, some pending in Delhi, some pending in the Karimganj district court. Your Lordships. Thereafter, both the parties sat down on 4 different occasions, reached a settlement.
Madam, the issue is, this is a habeas corpus petition.
Yes, Your Lordship.
You already got the custody of child.
Yes,
We'll make that absolute and leave you,
Absolutely. And
leave
leave
you
the
to
parties to be, I am.
take their steps wherever they
Your
want.
Lordships, because then that, we may be allowed to carry on the litigation.
Yes, of
wherever.
course.
Lordship, and I'll be deeply obliged to Your Lordships.
Then counsel for the petitioner submits that pursuant to the mediation proceedings undertaken at the mediation center, custody of the child, which is the main issue for consideration in this habeas corpus petition, has already been handed over to the petitioner.
Lordships.
However, she submits that the respondent agreed to various other terms and conditions whereby, all litigations between the parties were sought to be brought to an end amicably. Nonetheless, after executing the mediation agreement, the respondent has not been complying with the terms and conditions thereof.
Lordship.
Then counsel for the respondent is not in a position to dispute this submission. In view of the facts noted above, we hereby make the direction of handing over custody of the child to the petitioner, who is the natural guardian, within bracket mother, absolute.
Lordships.
However, the parties are left at liberty to take recourse of the suitable legal remedies
Lordships.
for redressal of their remaining grievances before the appropriate forum, without being prejudiced by any of the terms and conditions agreed before the mediator. The habeas corpus petition, proceedings of this habeas corpus petition are closed with the above observations.
I'm deeply obliged to Lordships.
item number 19 of supplementary list for admission.
May I please, your lordship?
Yes.
Sir, this issue has been answered by the honorable court, my lord. This is regarding the minor vending.
Minor events.
Yes, my lord.
Alright.
The railway station in the over Assam. my lord.
Mr. Sahewala was there
Yes, my lord.
for the other parties,
Yes, my lord.
the IRCTC.
Yes, my lord. We are under the railway authorities, my lord.
Minor event.
Are minor, my lord.
Who is representing the respondents?
My lord, R. Dev Sudhuri and Anik Singh, my lord.
Can you inform them, please?
I'll call him.
Rupam, call them and ask them if they are agreeable to this order. We'll see if they come up
My lord, yes,
and they agree to this,
my lord.
we'll pass the same order.
Obliged.
Yes.
Item number 9 and 10 of daily list for orders.
Yes.
In this case, Your Lordship, pursuant to Your Lordship's order, they have filed affidavits, Your Lordship.
Yes.
One affidavit in respect of Kamrup Rural, Your Lordship, I filed today, Your Lordship, few minutes back. I have been served with a copy.
Copy. What is the controversy?
Lordship, this is relates to Your Lordship. This PI relates to Your Lordship, protection of tribal belts and blocks, Your Lordship. constituted under chapter 10 of the Assam Land and Revenue Regulation, your lordship, 1886. Your lordship.
Okay.
There was a direction by this honorable court, your lordship, to evict the persons who are not protected under the law, your lordship, from the land, your lordship, tribal belt and block land, your lordship. And for that, your lordship, this honorable court directed them to file affidavit what steps they have been taken.
All right. So they provided you copy today.
One, so far as one affidavit is concerned, just few minutes back, I have
Lordship.
provided.
And the correspondence,
Lordship, for three districts, the affidavits were filed on 24th
Lord.
last.
okay,
Today, yesterday, the Kamrup Metro District affidavit was filed.
all right.
Today
Get down.
morning, Kamrup Rural and District of Morigaon affidavit, I'm still awaiting you.
Yet to be filed. All right.
Only of.
Affidavits on behalf of Kamrup Metro, Bongaigaon, Tinsukia, and Sonitpur have already been filed in terms of the order dated 3/3/23. Our council,
Metro also, your lordship,
Kamrup Metro
and Kamrup Rural.
and Kamrup Rural. Our little a small opportunity is sought to file the affidavit on behalf of the Morigaon district. Copies of the affidavits be shared with council representing the correspondents as well. Affidavit on behalf of Morigaon district be filed within 7 days. That will be enough. Will you be able to do it in 7 days? More time,
Lords,
within 15 days. List on 20th April.
Deeply obliged.
deeply obliged.
Item number 11.
Yes.
May please, your lordship. This is one more writ petition filed for the purpose of looking after the welfare of the prisons and prisoners in the state of Assam.
Okay.
Pursuant to your lordship's order, the committee has been constituted to inspect the jails.
Right.
That committee has already, I'm told that 9-10 jails they have already inspected. The
Okay.
report has not
Report has not come.
report has not come.
Committee was
other-
constituted by what order?
Order dated 5/12/2022, 15/12/2022.
15/12.
Original report. Lordship, I'm placing it.
This is 27 January. The notification whereby the committee was constituted, right?
Lordship, 6th of February 23.
There is one more order, Mr. Nath.
Lordship,
This is for Kohima
Lordship.
in particular. Yes. This court is informed that
Malad,
committees have been constituted
Annex
in all states.
Annexure 1, page 3. I'm for the state of Assam, Malad.
Okay.
And this committee, now they are inspecting the jails. I'm told that.
What about Mizoram?
Lordship.
And like monthly inspections are being done by them.
Any report?
Report is there.
Have you placed it on record?
Lordship, I have received those reports, but I haven't made any affidavit for them. Reports are there with me, copies are there.
You have to provide it
Yes.
to amicus curiae. Yes, you have already filed with the report. What is the latest report? Mr. Das, have you got the copy?
Yes, my lord.
So would you like to make any comments, any shortcomings noticeable? All of you, please make a compilation and provide it of the inspection reports.
I think it's major on that.
So we have filed an affidavit as part of the compliance.
Okay.
As far as the latest report,
In terms of,
I have received, my lord.
you received, so have you not gone through the,
My lord, I have gone through, my lord. This is with, my lord, there were several directions in the order passed by this honorable court.
yes,
My lord, few of the directions are here. There is signing of MOU and RDU for, my lord, distance learning. These are with regard to distance learning
Mr.
of
Das,
the, my lord,
you need
inmates.
to give a consolidated response
I
to
understand.
the
I
reports.
understand.
Maybe in form of bullet points what has been done, what has not been done.
I listen.
Then we'll carry it forward.
I listen. I listen.
Page 47 and 48, my lord, if it goes to.
But in
So
Assam-
only in Assam,
In Assam, 33 jails are there, my lord.
Hmm.
Then the committee has already inspected.
should,
They are-
even the inspection report of 10 should come on record.
Lordship, the committee has not given us the report. If the report comes, my lord, we'll.
Mr. Nath and senior commentator advocate Assam submits that the duly constituted committee has visited 10 jails in Assam and the factual reports thereof would be filed on record.
Report has not been submitted yet.
You get it.
Lordship,
Shall be filed on record within next 30 days.
Lordship.
The factual report in regards to jails in Mizoram has been filed in form of an affidavit and a fresh report has been presented today. Nagaland. Affidavit regarding condition of prisons in Nagaland has also been filed after and notification in terms of the order dated notification for constituting of committee in terms of order dated 15/12/2022 has already been issued.
Also, Arunachal.
Same order also. The Mr. Das, the amicus curiae, prays for time
Yes, my lord.
to go through the available reports and address the court regarding shortcomings, if any,
Lordship.
noticeable therefrom.
Much.
List in last week of May.
How like, my lord?
Deeply. Okay. Nagaland to affidavit. Entire thing is being reviewed.
Okay,
Automatic has to.
Ms. Chaudhary, where is 19?
19.
Ms. Chaudhary, are you agreeable to this order? Similar orders we have passed in same controversy,
Yes,
minor events.
yes, ma'am, similar, absolutely similar.
He has to agree.
Oh, yes.
Okay, very well. Dispose of in same terms.
Oh, sure, sorry, I was in another.
No issues, no
In
issues.
fact, both of us, they are in the same matter. Deeply obliged.
Yes.
Obliged.
Item number 12,
May it please your lordship. So
Yes.
this is with regard to issue involved herein is the, my lord, removal of unauthorized religious places, religious structures from public places, my lord. Now, so far as state of Assam and other states are concerned, my lord, they have filed their affidavit where from, my lord, prima facie, it appears that they have, my lord, been able to remove the structure. But problem is with regard to state of Arunachal Pradesh, wherein on one occasion, my lord, the state of Arunachal Pradesh, my lord, misconstrued the order passed by the Honorable Apex Court. The state of Arunachal Pradesh thought that there has to be an objection from the public, then only they'll have to remove. To that extent, this Honorable Court passed an order dated 17/5/2022,
Yes.
my lord, directing the state of Arunachal Pradesh to clarify their stand. Also, will kindly have the order dated 17/5/2022.
Yes.
In the second page, my lord. The paragraph starting from coming to the state of Arunachal Pradesh.
Can you tell us what was the precursor to taking suo motu cognizance? Was there a report anywhere?
There was an order passed by the Honorable Apex Court, wherein
Okay.
the Honorable Apex Court has been directed the cases filed before the Apex Court to the.
Which
various high-
transferred here, right?
Yes, ma'am.
Okay, okay.
Coming to the state,
Of Arunachal.
yes. The order dated 17/5.
No complaint has been received.
Yes, my lord. So the state.
In
of
some
Arunachal-
cases, they are proposing to allot the lands.
No, that can be done, my lord.
Yes,
It is removal and regularization.
right.
So the state government can regularize also.
So what is the latest status from
That's why-
Arunachal?
That's why, my lord, I'm appearing today for the first time.
Okay,
In fact, my lord, I will add something more to it.
yes,
In addition to what my esteemed colleague has pointed out. Unfortunately, my lord, in the case of the state of Arunachal Pradesh, apart from doing what they did, they also carried out practically the census of all the religious places. which amongst others include the famous Tawang Monastery, the tourist destination, the Gumfa in Arunachal Pradesh, where everyone goes. Those structures could not have been included at all. So they practically made a huge list. In fact, my lord, when I made further inquiries, it transpired.
You are
that even
appearing for
certain-
the state?
My lord, I am appearing for the state for the first time
Okay.
on request, my lord, in fact, to clarify certain positions.
Yes.
On personal queries, my lord, it even transpired that it seems over enthusiastic officials at the lower level, even the banyan tree around which the red cloth is tied up with some kind of a small stone, we call it shaligram, has also been included. So regardless of the timeline, every single religious structure, unmindful of its religious or historical importance. has
It's
been
good,
included
sir,
in the
that
list.
they have just made a census.
Yes.
They have not
census,
removed anything. No?
census.
So everything this
Yes.
is there now on record.
Yes.
Yes.
So, my lord, then when I told them, this will not do. You will have to carry out the entire review. We will file the affidavit. This is not the compliance of the order of the Honorable Supreme Court. You have
Yes.
to understand and read the order properly. Now it seems something has entered. They have understood, it seems so. This is the impression they give. So now, my lord, they have constituted a committee.
Okay.
I'll place the order. Order is here. Entire thing will be reviewed now, my lord, all across the state.
Let's see.
And then, my lord, they will give the report. I will file the affidavit, my lord, in accordance with that.
Mm. So how much time would be needed
My
to
lord,
complete this?
considering that because so much of mess has been created. In fact,
You
my lord, if
tell
anyone
us.
goes to Tawang,
Tell
my
us.
lord will find there is a famous Buddha statue, a tourist destination that has been included. The
Tell
famous
us.
golden pagoda in Namsai has been included.
Tell us, sir,
My
how
lord,
much
3
time
months
is,
at least, my lord, may I?
what do you say, Mr. Das?
This will be continue, my lord.
These things can't be done overnight. These things can't be done overnight.
That's true, my lord.
Let them have the survey, proper report, be placed on record, then we'll see.
Let there be a date after 1.5 months. Let
I-
us see how they
yes,
proceed. Then
An
we will
intermediate
continue.
date.
It's of interest to all of us.
Yes.
Nothing
Let,
personal here.
we'll take it up after about 6 weeks.
Yes.
If you may even file an interim report. Okay, then we'll,
Very,
if required, we'll give you more time.
very well.
Okay, senior counsel, what's your good name, sir?
My lord, I'm P.K. Tiwari.
Appears assisted by Mr. So-and-so, appears for the state of Arunachal Pradesh. He has placed on record copy of the order dated 28th March 2023, whereby, comma, a joint verification committee has been constituted pursuant to the deliberations held in the state level committee convened on 27 January 23 regarding the unauthorized religious structures within bracket regulation, removal and relocation, bracket closed, on the report submitted by the concerned deputy commissioners. It has been proposed to get a fresh verification done to find out whether the structures in question fall within the ambit of the directions issued in the unauthorized religious structures regulation, removal and relocation policy 2010. And Senior Council prays for and is granted 6 weeks time to place the latest status report on record.
In
List.
fact, the policy of, the policy of 2010 was formulated pursuant to the order of the Honorable Supreme Court. So that's it.
List on 29th May.
Deeply okay.
Item number 13.
My lord, I have been instructed to engage Mr. P.K. Goswami in this matter. He has some personal difficulty today. May I pray this matter be taken up after?
MSB, you are MSB Chaudhary.
Yes, madam.
The council representing the petitioner submits that she has been instructed by the petitioner to engage senior counsel,
Yes,
Mr. So-and-so, to
P.K.
represent him in this contempt petition. She prays that she may be allowed 2 weeks time to do the needful. List of 2 weeks.
My lord, can it be after the Bihu vacation sometime? in
List of 4 weeks.
Much obliged.
He may be allowed 4 weeks to do the needful. Ms. Chaudhary doesn't object the submissions so made.
Lordship. Great, I appear for 1 and 2, Lordship.
1 and 2. As per you, the order under contempt has been complied with.
Yes, Lordship.
Okay,
The calculation is made by the AG. We only have to forward it to the bank.
right.
My lord, there is some calculation problem and that has.
That can't be a
is-
subject matter of contempt.
That is, my lord.
Then you have to file a fresh writ petition
There
probably.
was an amendment that had come into place. That it come after the.
Very well. Yes.
Great.
Matter number 15.
Fifteen.
May I please, Lordship.
Yes.
Lordship, in this case, Lordship, actually, Lordship, I'm the petitioner, Lordship, applicant, Lordship. I have to file some reply, Lordship.
Reply.
Yes, Lordship, to the objection of this opposite party, Lordship. So, Lordship, can I only play, Lordship, there are some.
Concept of the petitioner place for is granted. 4 weeks time to file. Reply to what?
To the objection, Lordship. They filed on
Our
objection.
plea, my lord, this appeal
Is not maintainable.
not maintainable.
Yes, yes.
Reply to the preliminary objection raised by the respondents. Council. A list of the time paid for is allowed. List after 4 weeks.
Matter number 16.
Union of India. Yes, Mr. Chaudhary, what is the matter about?
Lordship, in fact, this is not filed by me. I'm not aware of who. The name
Okay.
is not reflected, Lordship.
Mr. B.K. Chakravarti. Earlier the name was
Lordship may kindly fix another. that I-
Mr. R.K. D. Chaudhary. DSG, Mr. R.K. D. Chaudhary submits that he needs time to seek instructions for appearance in this matter.
Lordship, Lordship.
List after 4 weeks has been. Have a look at the file.
Yeah, I will look that.
Okay, okay, yes.
Matter number 17.
May I please, your lordship? For condemnation of delay, my lordship, I filed.
Condonation of delay. Any objection, madam?
Lordship, regarding condonation.
No.
Lordship, may Lordship.
The
Matter.
merits will here, don't worry.
Yes, Lordship.
The instant interlocutory application has been filed seeking condonation of delay of how many days?
176 days.
176 days occasion in filing the connected writ appeal. The respondents have not 146. 146. What is the registry's calculation? What is the office report?
It is 146.
Is it 146 or 1?
146, 87 square.
146.
46.
I went to 176, I think.
Main petition of
146. The matter pertains to the writ petition was filed seeking a direction for compassionate appointment. Considering the grounds set out in the application seeking condonation of delay to be germane, and as the respondents have not objected to the delay, prayer for delay condonation, the IA is allowed. Delay is condoned. The registry shall number the connected appeal, writ appeal, and list the same for admission.
Deeply obliged, my lord.
Matter number 18 for hearing.
I appear for the writ petitioners. Our appeal by the state, my lord.
Yes.
The entitlement of the petitioners to arrear salary for the period from 1995 to 2001 prior to their regularization, my lord.
Mhm.
They were appointed in the year 1993 on planned.
Are you arguing or just giving the background?
Giving the background, my lord, right now.
Don't propose to argue the matter.
We can, my lord.
Then start.
My lord.
We have got the whole of the day with us.
My lord. The petitioner's case, my lord, in the writ petition was that they were appointed. The appointment letters lordship would find at page 30.
So this is the brief of the controversy you have given.
My lord, yes.
Let us read the reasoning in the impugned order.
My lord, we had gone, the writ petition was allowed, we came up in a writ appeal. We were given the liberty to go back for a review.
Review
My lord, the review order, lordship would find
that
page 100, my lord. 101, my lord. Page 101.
yes,
The review petitioner, at page 102, I'm reading, my lord. The review petitioners are represented by Swenson, learned standing counsel for the Department of Elementary Education. The respondents are represented by Swenson. The state has filed this review petition on account of the liberty granted to them by the division bench on 10/5/16, appeal number 46 of 2013, where the judgment of the learned single judge rendered on 10/3/2011 in WPC 5286 of 2004 was challenged by the department. Under this judgment, the writ court declared that the petitioners are entitled to their arrears salary from the respective dates of appointment as ME school teachers.
what happened in Abdul Haq Abbasi
My lord, in Abdul Haq Abbasi, the claim was,
appeal?
my lord, it
Whether-
was the rejection of the,
Writ petition was dismissed, whether it was carried in appeal or not.
yes, my lord.
What happened?
My lord, the appeal upheld the order of dismissal.
Okay. Okay. Yes.
For another group of ME school teachers, the learned judge in the WPC number 5705 of Abdul Haq Abbasi and 15 others by the state of Assam and others on 3/10.
That stood confirmed by division bench
My lord, yes.
on 25/2/15.
Yes, madam. Review
Yes.
petitioners' arguments. Standing for the review petitioners, Mr. N. Sharma, the learned standing council submits that because of the contradictory decision of the coordinate benches for similarly situated ME school teachers, this review petition is preferred by the department. He contends that since claim for arrears was denied by the court in the earlier decision in Abdul Haq Abbasi, the said verdict having been approved by the division bench to dismissal of the writ appeal, this court should retract its positive direction given on 10/3/2011 in favor of the ME
No.
school teachers in WPC bench.
The distinction is there,
My lord, yes.
irregular and illegal.
Yes. Now, the committee, my lord, which had taken up the task,
Yes.
they were although classified as irregular. If lordship has page 107 for a moment.
What is the order of regularization? What does it convey?
The order of regularization.
And
did
it's
not
your agreement in review. Mr. Chaudhary argues
Yes,
whether this is the argument.
that is the argument. Madam. If lordship has page 107 of the repetition, madam,
Yes,
para 11.
yes.
What emerges from the above narration is that the responded repetitioners were formally selected by a competent body, but they were appointed against
Non-sanctioned post.
If the posts were non-sanctioned, my lord, a classification merely as irregular, my lord, would perhaps not stand in the eyes of the law. It would remain an illegal. The appointment will remain
That's the
illegal.
finding of your committee,
No,
committee constituted by the state.
that is a nomenclature, my lord, but the actual status of the petitioners have to be seen. Because we have not denied them the past service for the purposes of pension, etc.
You see, here the issue is,
No,
the report of committee is not challenged by you.
it is not.
That has become final.
My lord.
So that status of irregular, that has been acted upon by the state by subsequent regularization.
Yes.
So where is the order of regularization?
Even the illegal teachers were so regularized.
5 years later.
My lord.
Yes. So where is the order of regularization?
Yes, one of them is at page 88, my lord.
88,
Page 88.
80 or 88?
88. The type copy is at page 18. One of them, for the one of the people. In pursuance of DE Assam letter memo number so-and-so, wherein government circular number so-and-so has been indicated as circular number so-and-so. In continuation of the order issued to Srimati so-and-so. Is hereby placed adjusted in the engineering college campus. And so on. This is the adjustment. Order.
This
This is the adjustment order. And
number one, para number one says,
my lord,
she will not claim career salary.
that was, my lord, what was challenged by the repetition saying that they were on a condition where they could not have contested.
Oh, contested that, yes.
So that has also been discussed by the learned single judge.
That was in the year 2002. And when was the writ filed?
My lord, that was filed in 2004.
So not much delay.
The delay is, the delay is not. And the only issue that, my lord, the department now has is that when they were against the non-sanctioned posts, could they be termed as illegal or irregular, and whether the nomenclature of
Just hold on.
nomenclature by the report.
Para number one
My
of this regulation order, that concludes everything. If that period is to be counted for pensionary benefits,
Yes.
you bind the employee down, you will not claim. that is unconscionable contract.
So. But otherwise that illegal part is what, my lord, that they were appointed against non-sanctioned post and therefore. We will be.
You could have chosen not to confirm them, not to regularize their services. Then the litigation would have been in a different flavor.
The cabinet approval was there for the regularization.
And this order says, ask services to be counted for pension,
Yes,
and they have given services.
they have.
So you want them to be branded as contractual labors for a period which they perform, which otherwise will be counted as a regular service for pension. Oh, that's,
Becomes a bit contradictory.
so you will not permit the senior counsel to justify his brief.
Of the record, my lord, I was in some difficulty in justifying my stand.
That's right.
Given the Manohan Committee report, the term irregular and that we have extracted service.
This, apart from regularizing the services,
My lord,
your order says
giving
past services will be counted.
for pension. We counted
So
from to 90.
pension, the pensionable service is regularly performed service.
Yeah.
It can't be ad hoc service that
Just to
can't
qualify.
count for qualifying service as pension. Then, yes, at least give us the benefit of your submissions.
Or whatever little bit I would have submitted has already fallen from your lot. The honorable single judge has gone into each and every aspect, dealt with the fact, even there, they tried to come out with a case that they should also be branded as illegal. Although that has not been gone into that much because it was not even required. The committee very clearly spelled out that they could not be blamed for being appointed against, having been duly selected. These people cannot be blamed for having been appointed against non-sanctioned posts.
Surplus posts, basically. It
But
was
that is by
surplus.
the
At
committee.
that point of time, there was a scheme. They were planned posts. They were appointed to that and they were allowed to continue. The posts were not retained. So from 95 to 2000.
So that is a basically they were surplus employees.
Almost.
In Rajasthan, there were surplus employees in PWD. They were there then adjusted in different departments.
Here
That's
they
how
were-
they dealt with it.
Here they have been adjusted against the same department, the same post that they were holding. Only from 95 to 2001, we could not retain the post because the plan was not there.
Plan was
The scheme was not there.
scheme.
But they continue to serve on the same. They continue to discharge.
And that is exactly what the honorable single judge has held. Having extracted the service, how can you deny them? the
Yes. Past services have been counted as qualifying service. There is no question. He is not being counted as regular service. Pay and serve work. It's not a case of no pay for no work.
Obliged.
Segment is on. Thank you. Well,
Letter numbers.
May it please the lordship.
yes, please. Brief recap, please.
Lordship, here only the issue is that we have basically challenged the order of the learned single judge on the
Yes.
point of whether an issue relating to recruitment of IS officers through nomination
Hmm.
can be challenged before the writ court.
Red court
According to us, it should be
should be the CAT.
the CAT
Yes.
tribunal. So on this case, lordship, we have come in an interim order wherein we did not argue about the merit of the case, but the learned single judge, while hearing the matter on maintainability,
Okay.
went ahead and gave an opinion regarding.
We
the
give you an option before we proceed further. We give you an option. Supposing we don't accept your challenge on the ground of maintainability, would the state be happy if we make an observation that any of the findings recorded in the impugn order would not come in the way of the state
Yes.
in prosecuting the writ petition on merits, the arguing the writ petition on merits.
Lordship, we are agreeing to taking this matter to the CAT so that we do not lose any forum.
No, that's a different thing. That's presuming that your argument weighs with the court.
Because the
Supposing it
learned
doesn't.
single judge has already given an opinion regarding the maintainability.
Maintainability aspect only we are saying that if we hold that maintainability issue, the single judge was justified in observing so. Would you be happy if we make an observation that you can raise all objections, arguments on merits before the single bench and the findings on merits would not prejudice the final outcome of the writ petition?
Yes. That is one aspect.
Yes.
But we do not want to give our response before the learned single judge because that is not the right forum.
Okay, very well.
That is my case.
Carry on.
But here today, the case is coming for a very different reason. Today is not for the hearing, Lordship. They have filed an IA whereby they have raised the issue that one of the officer who is promoted on, who is recruited as IS officer, Rakesh Agarwal, who is one of the appellant herein, that there was a pending vigilance case against them. This is the
IA.
issue today.
Where is the IA?
No, I am.
Additional affidavit. And Lordship, today my job is to give a response to that.
Would you?
What had happened, my lord, on
Yes.
last occasion, my learned friend started with an argument that we are guilty of suppression of material fact. We have brought on recorded document, which is, concocted or something like that. So it is in that context, my lord, we filed a reply. While going through the RTI reply, we found, my lord, not only that, what my learned friend is saying is not correct. My lord, even a vigilance case was pending against the one of the
Appellants.
that I have brought to your lordship's notice,
That
because
is-
it will have a bearing.
That is an affidavit in which appeal?
My lord, in writ appeal 167 of 2018, in states appeal we have filed. Now, my learned friend on last occasion made that submission, my lord.
Yes.
My lord, if your lordship would kindly come to page number, before that, let me place that. If your lordship would kindly come to order to page 2. Yes, please come to page 76 of the memo of appeal.
Yes.
Yes.
76.
No, 76 or 165, yes, writ appeal number 165.
165.
Rakesh Agarwal.
Yes.
And 60.
Page 76. By referring to this document, an argument was sought to be developed that this is a truncated document. My lord, we suppress the actual document from this honorable court. My lord, will kindly, on top, there is a 399 mark, my lord. Page, after that annexure 7, the page
Yes,
number
399.
399.
Yes.
Yes, it has a bearing, I'll come to it later. So according to my learned friend, this document was circulated to as many as 32 parties. How come this is not there?
Yes.
Thereby, he was trying to make a submission, including, my lord, the copy was marked to the director for publication in the official gazette.
Yes.
Now, how we annex this document, that we have brought out in the affidavit.
Yes.
Now, my lord will kindly take the additional affidavit at page number 186.
In 167.
No, my lord, yes, retable 167, yes. It was the signing board. Acha, okay, okay.
186.
186, my lord.
Yes.
This is a communication by the personnel department to my lord one Midhu Kumar Mohanta, who was General Secretary of the SCS Officers Association.
Yes.
Kindly see the subject, furnishing of information under RTI. With reference to your RTI application dated 6/1/2018, I am directed to enclose the information sought available in the department as follows.
Yes.
Copy of all note sheets, page 1 to 43, and all paper under consideration, serial 1 to 399 of file number. That's why, my lord, that document.
399.
Yes. Now, my lord, will kindly come to the next page, my lord. This was another communication by the personnel department, where if your lordship kindly comes to serial number 6, my lord, there's a reference to the letter which I placed at page 186. Then my lord will kindly come to page 188. These are all part of the, my lord, this
RTI.
RTI. Please come to the last para. As per the format of UPSC, state government-wide notification has to declare the post held by non-SCS officers nominated for selection to IS to be equivalent to rank of deputy collector. Perhaps the post may be declared equivalent to the rank of deputy collector. It was on 24/10/15. Then, my lord. Yes, and my lord, page 88, my lord. Kindly see, my lord, a draft at serial 330 is placed below for consideration. Now, my lord will kindly come to draft testimony. Please come to 194, my lord.
Yes.
This is the document, my lord, which we have annexed at page 76. And 399 is another copy marked subsequently. This is 330 and 399 as well. Kindly see, my lord, where does it here the signature of the endorsement to the other parties are available? So that is why we have annexed this, my lord. So where is the question of suppression of material fact? And my lord, learned friend made a very serious allegation that our association members are coming in the way of finding out all these copies.
That was his personal experience. Personal experience as well as as a status of AG. Yes. Okay. So now, Saikya, where
My learned friend wants to argue, so let.
no, he was not proposing to argue. Now, what is to be done today?
Yes, Lordship, the issue is now, while that deliberation was going on, they brought a further allegation that he wants to say something. I do not want to interrupt.
Sorry. Unintentionally it came out. Please.
Yes, please.
So there is another issue that against Rakesh Agarwala, there is a vigilance case. That is there another statement in their affidavit.
Yes.
And Lordship was pleased to ask me very pinpointed question that is that correct?
Yes.
So I have the records, 80% of the records are with me. One file I have yet to retrieve. I have a document issued by the Finance Taxation Department, 29 January 2018, whereby it is written by from the Joint Secretary to the Government of Assam, Personnel B Department, subject appointment of non-SCS officer to IS for select list 2016, reference so and so.
Yes.
With reference to the subject above, I am directed to inform you that there is no departmental proceedings / criminal proceedings initiated against Sri Rakesh Agarwala, Joint Commissioner of Taxes, now Additional Commissioner of Taxes after 21. This is the document.
Mr. AG, it's very crafty kind of drafting.
No, my lord.
Just hold on.
Yes.
The communication on which reliance is placed, that is again a document issued by the Government of Assam.
Yes.
On which the respondents rely upon.
Yes.
Please read that. State Vigilance Commission.
Sorry.
The inquiry is by the State Vigilance Commission.
Agor, in their affidavit.
Yes.
So here it is said that there is no departmental proceedings / criminal
So
proceedings.
please 196 read. Read the document at 196, which Mr. Chaudhary referred to. Why not a straightforward answer to this?
No, I have to, whatever I have to speak, it should be based on the record. So I have the original file. I am coming there because we have not filed the affidavit till now. Because
just read this, please.
I am directed to enclose here the integrity certificate of Rakesh Agarwala, Joint Commissioner Arunima Chaudhary, Assistant Commissioner for favor. It may be mentioned that a vigilance inquiry against Rakesh Agarwala of so and so
by the State Vigilance Commission. State Vigilance Commission.
Yes, that later date is 30th May 2017.
Yes.
And this letter is of 29 January 2018.
When was the recommendation made?
Recommendation made sometime in the last September, December and February 2018. February 2018.
2016.
So what was the fate of that inquiry, sir?
That inquiry, Lordship, very interesting inquiry. One file I am yet to see.
Interesting or otherwise we are not bothered. What was the fate we want to know?
Final fate is that this is.
And what is the date? Date of conclusion.
That file, Lordship, I have received the file from the Finance Department as well as Personnel Department. That closure report is in the vigilance sales department. That file I am going to find out, Lordship.
Find out.
The closure is there. The
Find out
closure, that is
date-
the 80% of the records I have
Date
described.
of closure would be
Yes,
the relevant.
very important, Lordship.
My lord, can I just to.
Because I have to stitch the gaps. The
Yes.
dots I have to stitch.
Yes, yes.
So that vigilance cell, because from this I thought that
When we-
records will.
No, but these two things you are referring to, something different is indicated.
No, that was about 8 months earlier.
Maybe. So you just let us know the closure report.
Yes, Lordship.
Date.
I will give. That is what the closure must be done by the vigilance cell.
So that date would be there
That
relevant.
will be there, Lordship, because it has moved, because that is why I'm saying it is interesting. These vigilance cases were lost at the initiative of the presiding officer of the Chief Vigilance Commissioner, H.M. Kere. He passed the order, Lordship, an inquiry be conducted into the conduct of the vigilance angle of the officers of the Commissioner of Taxes who dealt with the annual returns and passing of the assessment orders for value-added tax during the last 10 years. He made a general thing, wherever there is a.
Irrespective, pendency of inquiry is a fact which would have a material bearing
On the
on your
selection.
recommendation.
Absolutely,
and selection.
Lordship. I fully
So-
agree to that.
So let us see whether if it has been concluded,
It is
chapter closed. So you satisfy us that it was,
Lordship.
There is one more aspect, my lord.
yes,
My lord, when this was indicated, please come to the next page. Very interesting now.
yes.
Please see. Now, my lord, personnel department is writing to finance.
Hmm.
With reference to the above, I am directed to request you to inform this department if any complaint has been lodged or departmental proceeding, criminal proceeding against Rakesh Agarwala after 21/12/17 till date. What is this, my lord? Now, the officer is recommended by UPSC for appointment to IS. So and so has requested for the above information urgently. Now, my lord, all of a sudden, why this date has, my lord, 20, what is the significance of this date? 21/12/17. Now this, my lord, the personal finance department writes at 198. This is the document which my learned friend showed this morning. With, one second. With reference to the above, I am directed to inform you that there is no departmental proceeding, criminal proceeding initiated against Rakesh Agarwala.
What we want to find out is what is the fate of the vigilance? inquiry?
My lord, vigilance case, it is a preliminary, maybe at this stage. Only when a regular inquiry is filed, then only it will result in a criminal case. So at that stage, maybe criminal case or a departmental process not there, but
If it-
vigilance inquiry was very much there.
If it was concluded before the recommendation,
Before, yes.
let us see the date.
Yes,
Yes.
that is what I am going to place before this court.
So why not today?
Yes.
Why, Lordship? Three files came to me.
This is like a very clear.
Lordship, one thing is that they are not in a hurry, neither we are in a hurry. We have to file a detailed affidavit.
We have
One thing is,
constituted,
Lordship will kindly see this record.
Mr. AG, very sorry to hear that statement. We have constituted a special bench for this very purpose.
Absolutely, that is why
So
I am saying.
parties may not be, parties may not be in a hurry.
Lordship, fact finding cannot be done in a day. We need some time. And I am, what
Let us
I am
see
requesting is that.
How much time was given?
2 days time, tomorrow.
How much time was given?
Tomorrow at 2 o'clock, I will file because after going, we have to go through about 300 pages to find out this, because there are a lot of disconnections.
That is the responsibility which comes with the office of the AG.
No.
If you don't tell us that you have to go through with 300 pages, 200 pages.
No, no.
We'll have to, that
My
is a part
team
of the
is doing-
job.
My team is doing, Lordship.
That is
And
the part,
finally-
yes. But this is not a very fair statement that we have not been given time.
No, no.
The last date, the order was passed on
Yes,
21st
Lordship,
March.
my answer is very clear,
Yes,
that there is no pending. I have a record with me. This is the final, Lordship, wants the certain additional information.
we want
Those
precise
info-
information, Mr.
Yes,
Sakia,
Lordship, this file,
that,
there is an additional file which is not with the finance department, neither with the personnel department.
yes,
So the final call had been taken by the anti-corruption, this
vigilance.
vigilance department, that comes under home and political department.
Mm.
That file, Lordship, we have already sent a request.
Okay,
This
when will you get the file?
By this evening, I will get that.
Okay. Mr. Chaudhary,
My lord,
let the file come.
my lord, tomorrow, my lord,
Not tomorrow. Tomorrow we have that
my lord.
environment bench at 2.
Okay.
So we'll probably take it up on no, it goes to 10th of April. No, it can't be done before.
My lord. Because next week, my lord.
Learned
Yeah,
Advocate General
anytime.
submits that he has not received complete information regarding the averments made in the additional affidavit filed on behalf of dated
It was filed 23rd, my lord.
23rd
23.
March 23 filed by the respondent number 1 in Spirit Appeal number 167/18. The requisite information be procured and be kept available for the court's perusal on the next date. The matters are released from tied up category list on 10th April.